You come home after a long day, something feels off. Things have been moved. Your landlord has a key. But did they actually have the right to just walk in while you were gone? Most people have no idea what the law actually says about this, and the answer might genuinely surprise you. Welcome to Plain Verdict, where we take the legal concepts that affect your everyday life and break them down in plain language. No law degree required. Today we're answering one of the most commonly searched tenant questions on the internet. Can your landlord legally enter your home without telling you first? The short answer is, in almost every country in the world, no. Your landlord generally cannot just walk into your home whenever they feel like it. But the details of when they can enter, how much notice they need to give, and what happens if they break the rules. That's where it gets interesting, and that's exactly what we're unpacking today. Before we get into specific countries, it helps to understand the legal principle sitting behind all of this. In most legal systems, there's a concept built into rental law that gives tenants what's called the right to quiet enjoyment. Don't let the name confuse you. It has nothing to do with noise. Quiet enjoyment means your right to live peacefully in your rented home without interference from your landlord. It essentially says, yes, the landlord owns the property, but while you're renting it, it's your home. And that distinction matters enormously in law. Let's start with the United States. Because the US operates under state law rather than one single federal rental law, the rules vary depending on where you live. But the general standard across most states is that landlords must give between 24 and 48 hours notice before entering. California requires 24 hours written notice. New York has similar protections. Texas is a little more flexible for landlords, but still requires reasonable notice. The purpose of entry also matters. Landlords can typically enter to make repairs, show the property to prospective tenants, or conduct inspections. But they cannot just drop by to check on things out of curiosity. In the United Kingdom, the rules are similarly protective of tenants. Under the Housing Act, landlords are required to give at least 24 hours written notice before entering a rental property. Verbal notice technically counts in some circumstances, but written notice is the standard expected in practice. Entering without proper notice in the UK can constitute a breach of the tenancy agreement, and in serious cases, it can even amount to harassment under the Protection from Eviction Act. British courts have historically been quite firm on this. A landlord who repeatedly enters without notice can face significant legal consequences. In Australia, tenant protections are governed at the state level, similar to the United States. But across most Australian states, the standard is clear. Landlords must provide written notice before entering, typically between 24 and 48 hours, depending on the state. In New South Wales and Victoria, for example, the law requires at least 24 hours written notice for most types of entry, including inspections and repairs. Queensland has similar protections. What's interesting about Australia is that tenants can actually refuse entry if proper notice hasn't been given, and landlords who repeatedly enter without notice can face formal complaints through their state's tenancy tribunal. Australia has invested significantly in making these tribunals accessible and affordable for regular tenants, which means the protections aren't just theoretical, they're genuinely enforceable. Now, and this is important, there are exceptions to the notice requirement in virtually every country. The most significant one is genuine emergencies. If there's a burst pipe flooding the apartment, a fire, a gas leak, or any situation where immediate entry is necessary to prevent serious damage or danger, landlords can generally enter without notice. The keyword there is genuine. A landlord cannot decide that a minor maintenance issue suddenly counts as an emergency just to avoid giving proper notice. Courts are well aware of this tactic and don't look kindly on it. Other exceptions that exist in some jurisdictions include situations where the tenant has clearly abandoned the property or where a court has specifically granted the landlord access rights. So what do you actually do if your landlord enters your home without permission? Step 1. Document everything immediately. Write down the date, the time, what you observed when you returned, and take photos if anything has been disturbed or moved. Step 2. Send your landlord a written message. Email works perfectly. Keep it calm and factual. Reference the relevant law in your country and clearly state that you expect proper notice to be given going forward. The reason you want everything in writing is simple. It creates a paper trail. If this ever escalates to a legal dispute, your documented communication becomes evidence. Step 3. If it continues or escalates, you have real options. Contact your local housing authority or tenancy tribunal. In serious cases of repeated illegal entry, you may even have grounds to terminate your lease without penalty or pursue damages. The law is almost universally on the tenant's side here, but it only protects you if you know your rights and respond correctly when they're violated. Most landlords who enter without notice are banking on the fact that their tenants don't know what the law actually says. Now you do. If you found this useful, the next video covers what happens when landlords illegally withhold your security deposit, another area where knowing the law makes an enormous practical difference. Subscribe to Plain Verdict so you don't miss it, and if you have a legal question you'd like us to break down, drop it in the comments below.